Okay. Are you weird?
Good afternoon, everyone. It's 1 o'clock and we will go ahead and begin our presentation. First of all, thank you for joining us today for this very important webinar on the anatomy of a Supreme Court inverse condemnation case, specifically focusing on the landmark decision in the City of Oroville case. We have a lot of first-time attendees today, so let me briefly introduce myself. My name is Vladimir Viserevov, Risk Manager for East Bay Municipal Utility District and the Chair of the Water Leadership Group. I'm honored to welcome you to this session, tailored specifically for California water and wastewater risk managers, and we have a lot of legal counsel with us today. Our objective is to dissect this case comprehensively, exploring its background, the court's reasoning, and the implications that this case has for water and wastewater utilities across California. By understanding the nuances of the Oroville decision, I believe that we can better navigate the legal landscape, enhance our risk management strategies, and ultimately protect our communities and resources more effectively. Thank you once again for joining us. I'm confident that today's discussion will be enlightening and beneficial for all of us. Without further ado, let's begin with our first speaker, Paul Fuller, CEO of Allied Public Risk, who will be moderating today's webinar. Paul?
Great, thanks, Vlad, and hello, everyone. Well, without question, inverse condemnation is a unique species of liability. It's confusing, it's complicated, and it's calamitous. But the worst part is its potency against public water systems. Inverse condemnation is the perfect legal cudgel because water delivery systems, which are public improvements, they have a propensity to fail. And that leads to water going places it shouldn't, and that frequently leads to physical intrusion on private property. Now, fortunately, our guest speakers have substantially leveled the playing field, and they did that by successfully arguing a landmark inverse condemnation case before the California Supreme Court in 2019. However, as our speakers will affirm, this legal theory, it's still dangerous, and the holding, although favorable, is wrought with uncertainty. I'd like to now introduce our guest speakers. Bern Connolly and Peter Erhausen are attorneys with the firm Gibbons and Connolly in Pleasant Hill. The firm represents California public agencies and JPAs in civil litigation matters, including insurance defense and coverage disputes. Bern and Peter are honors graduates from the University of California Law, San Francisco, with AV ratings from Martindale-Hubbell. That's top 5% of attorneys in the country. Both are members of the Order of the Coif and were named 2020 Attorneys of the Year by the California Lawyers Association. Now, in terms of structure today, Bern and Peter will transition to one another throughout the presentation. Afterwards, I'll initiate the question and answer session, and then Vlad will finish up with his concluding remarks. So with that said, Bern, the floor is yours.
Thank you. Is my screen showing up that says inverse condemnation?
Not yet, Bern.
No.
Okay. I hit share. Is that working?
Not yet.
Do I have to be enabled by the...
No,
All right.
Bern, you have
wait.
administrator.
I got it. I think I did it. How's that?
It's on.
There we
Yep.
go.
Okay. So are you seeing the inverse condemnation not quite as scary as it used to be?
Yes.
Great. Great. Okay. So what we're going to talk about today, as soon as I get this thing to work from page to page, here we go. What we're going to do is break this up where I'm going to talk first about what are the theories of liability you can get sued on in a water main break case, what are the elements of the causes of action and the defenses, and then how inverse condemnation is different and why it's particularly dangerous. And then Peter's going to talk specifically about the Orville case, which he argued to the California Supreme Court. And we're going to talk about issues of duty breach causation damages, one slide on insurance coverage, some on damages, and some on risk avoidance measures. So we're going to cover a lot of ground. And what I've tried to do is put in these slides, which I'm sure Vlad's going to make available to everybody, sites at the bottom of each slide so that you've got cases if you need to follow up. But I'm trying to touch on the topics here at this point. So you have a water main break with property damage. What can you get sued for? The typical causes of action are going to be negligence, nuisance, inverse condemnation, or dangerous condition of public property. Those are the causes of action that are typical that you'll see when you first get the claim come in. Now, on a negligence claim, generally speaking, public agencies are not liable for simple negligence. Under Civil Code Section 1714, which says everyone has to exercise reasonable care not to injure another, that doesn't apply to public entities because we're statutorily liable only. It has to be a statute under the government code or the vehicle code or some other statute that imposes a duty. The Zelig case that's cited here is a case in which a distraught husband comes to divorce court and the husband and wife are sent down to a mediation, and when they're walking down the hall, he pulls out a gun and shoots his wife. And she is killed, and the children sue for wrongful death, claiming that they didn't provide adequate security, and they should have, basically, he'd managed to avoid the metal detector. They should have done a better job on security. They said, you can't sue for negligence in just maintenance of your premises. Instead, you have to use the dangerous condition of public property statute, Government Code Section 830 and following. So generally, this case stands for the proposition that negligence cause of action is demurrable. By contrast, dangerous condition of public property is the main statute you'd be sued for under tort. And under dangerous condition of public property, you have to have a substantial risk of injury when the property is being used with due care. And that doesn't mean just any plaintiff being negligent. That means the public generally using with due care. You have to have actual or constructive notice or a negligent act by the entity in creating it. Now, the case that's cited here, Metcalf versus San Joaquin, is a case where a driver comes up on a roadway and there's a railroad that splits off in sort of a Y, and it crosses the roadway twice. So there's a railroad ahead sign, and then at least the argument was the driver got confused because they cross one set of tracks, then they cross another one, basically looking one way for the train, and it comes from the other way. The jury returned a verdict that said no actual or constructive notice. And the reason I put this case in here is it's very important that the notice of a dangerous condition has to be notice of a danger, not just you knew the road was there, or not just that you knew that there were railroad tracks there, but you knew as an entity what that there was a notice that it was dangerous and didn't take action. So Metcalf stands for the proposition that you have to show notice, actual or constructive, or negligence in the creation of the condition. And of course, design immunity applies. So if you show that it's a design decision, then you have an immunity as well. Nuisance is something that entities often get sued for when it's either a sewer backup or earth movement or a water main break. This is a common law that comes down from English common law. Civil Code Section 3479 says a nuisance is conduct that obstructs the free use of property so as to interfere with the comfortable enjoyment of life and property. Now, the important thing about nuisance is you have to file a tort claim, and the design immunity applies. So there are affirmative defenses that are available for that, unlike what we'll see later in inverse condemnation. Lucier versus San Lorenzo Valley Water District is kind of an important case for nuisance because this was a collection of debris, timber and debris that had gone into a swale and then during a storm washed onto the plaintiff's property. And the court said, you're not liable for nuisance. This is a natural condition. The district didn't create it. The district didn't put the timber and the debris there. And so unless the action that you're taking is intentional, unreasonable, reckless, negligent, or ultra hazardous, then you don't have nuisance liability. Now, if you have a dynamite factory next door to my house and it blows up, I mean, maybe it's an ultra hazardous activity, so you won't have to show specifically negligence, but otherwise you have to show some kind of affirmative act. And this becomes important when you get a backup claim or a break claim, because in the absence of some affirmative act, nuisance wouldn't apply. There's a split in the case law on nuisance and dangerous condition. I've got 3 cases that say you can't sue for nuisance if the dangerous condition cause of action is there. You can't get around the actual or constructive notice requirement or the substantial risk of injury with due care by simply using nuisance because it's a simpler cause of action. There's another case out there that says, well, because you can state a cause of action under one, there's no reason you can't state a cause of action under the other. The cases are split on that, but typically if you get a dangerous condition and nuisance, it's worth taking a shot at the nuisance and trying to knock it out. Trespass is another thing that's often sued on, but there's no case law on this. And so whenever we get a case in the office where they're suing for trespass and dangerous condition, we try to strike it under the Zelig reasoning that it's basically occupied by the dangerous condition statute. Sometimes they try to sue the employee instead. You're not allowed to do that. The Van Kempen case versus Hayward Area Park District is basically a sidewalk in a park somebody tripped on, and they thought, well, let's sue the maintenance supervisor instead of the district to try to get to a general negligence claim. They said, no, you can't get around the dangerous condition statute that way either. Which brings us to inverse condemnation, the main topic here. Inverse condemnation is based on the California state constitution, which says private property may be taken or damaged for public use only when just compensation ascertained by a jury, unless waived, has first been paid into or into the court for the owner. Now this works in both directions. This works for eminent domain. I'm taking your parcel because I want to put something on it. I want to build a road or a building. It also is what we call inverse condemnation when the action of the entity has caused taking or damage. This is different than the federal constitution because the federal constitution only refers to taking. California's is more broad and it refers to taking or damage, and therefore can be used for accidental property damage claims. So inverse condemnation. This is the CSAA versus Palo Alto case that we lived under from 2006 until 2019. Very damaging case. It was a sewer backup case. And this particular paragraph that I've included here is actually a correct statement of the law. The case gets worse as it goes along, but it starts out with a statement of inverse condemnation lies where damage is caused by deliberate design or construction of the public work. The cause of action is distinguished from and cannot be predicated on general tort liability or a claim of negligence in the maintenance of a public improvement, but damage caused by the public improvement as deliberately conceived and altered or maintained may be recovered. That statement's okay. Unfortunately, in what they did in the CSA case is there's a homeowner with a sewer backup. The CSAA was their homeowner's carrier, and they basically replaced the lateral, put a new one in, and then a second sewer backup happened. Now, on this particular street, there was no prior history of sewer backups. The expert witness, though, for the homeowner's carrier said, look, this has a 0.5% slope. It had standing water in it. It had tree roots, that had cut into the pipe at the Y where the lateral meets the main, and every 8 feet further, it was a BC clay pipe. The tree roots had gone in, and therefore they must have been there for a while. As it turns out, the city had hydroflushed the pipe within the last year and a half, but as I found out later from the CSRMA board members who are all engineers themselves, hydroflushing is not enough. You have to actually inspect the line or use a cutter. In any event, the importance of CSA versus Palo Alto is they borrowed from the flood control laws, and they said, look, it was meant to carry the poop away from the house. Instead, it brought it into the house. Therefore, it failed to function as intended, and therefore, you're liable. And so basically shifted the burden of proof to the city, and it imposed strict liability. And they did this by borrowing from flood control law, but basically they turned inverse condemnation on its head. Instead of saying it was functioning as you designed and it caused damage, they're saying it failed to function and therefore you're liable. So it created basically a strict liability standard that you couldn't avoid. Now, I'm going to talk about a few cases that decided inverse condemnation leading up to, other than the Palo Alto case, leading up to the Oroville case. Areola is one of the main cases. This is a flooding case. It's called the Pajaro Creek, and it ran through county property. Over the years, it got clogged up with vegetation. The problem was you can't actually clear out a creek without approval from Fish and Game, and the state didn't give them approval. So when a storm came along, the water backed up, it overtopped the creek, and then it flooded some local farmland. It actually was such a big storm that it hit Highway 101, and that channeled water back as well, but it caused a major flood. What the court decided was that a plan of maintenance a plan of maintenance, not just individual maintenance workers making a mistake, but the plan of maintenance, if it's deliberately unreasonable, that it can amount to the intent that you need to show an inverse condemnation claim. So they indicate that they have to show awareness of the risk and deliberately chose a course of action or inaction in the face of that risk. And this is a quote from the Areola case. Knowing the failure to properly maintain the project channel posed a significant risk of flooding, counties nevertheless permitted the channel to deteriorate over a long period of years by failing to take effective action to overcome the fiscal, regulatory, and environmental impediments to keeping the project channel clear. This is sufficient evidence to support the trial court finding of a deliberate and unreasonable plan of maintenance. Very frustrating case because the county had the argument, look, we legally couldn't clean up. We couldn't do what you were talking about here because the state wouldn't apply. The Court of Appeal, really looking to uphold a verdict, said you didn't show that you could have appealed or done something better, and therefore we're going to support the verdict. The other issue becomes a fix it when it breaks. The issue then is, did you have an inspection or maintenance program reasonably calculated to spot potential risks? These are the main these first two are the main water main break cases, Pacific Bell versus San Diego and McMahon's versus Santa Monica. In Pacific Bell, they had, I think it was a 60-year-old pipe, but it was past its useful life, hadn't been replaced, but the city of San Diego had gone twice or three times to the voters to try to get additional tax revenue so that they could do capital improvement projects and replacements, and were voted down. And so instead, they had what the court called a fix it when it breaks policy. They also didn't have sufficient monitoring in the court's opinion. So they decided that even though negligent maintenance cannot give liability for inverse condemnation, if there's a deliberate decision to shift the risk to avoid the cost of maintenance that is, quote, deficient in light of a known risk inherent in the improvement, that you can have inverse condemnation. So Pacific Bell is basically a pipe past its useful life. McMahon's of Santa Monica is a flooding of a restaurant at the pier, and it was caused by corrosive soil conditions that there was a cast iron pipe that had deteriorated over the years. And again, in both cases, they found insufficient plan of maintenance. Now, Ambrosini I throw in because it's actually a classic case of more likely what you should have for an inverse condemnation case. Ambrosini is a case where the sanitary district had an outfall line that went out to the river, Salinas River, and it was built in 1941. And in 1955, they added, because they had to do clean out of the line, they added 4 more manhole covers to it, but they didn't seal them. The other manhole covers were all screwed into place, but these were pop-off manhole covers. They had a huge storm, 17 straight days of rain, and the river rose by from 14 feet, which is where the outfall was, up to about 47 feet, which was higher than the plant and it was higher than the outfall line. So the manhole covers popped and it flooded into a celery field, and the court found both nuisance and a dangerous condition. What they said, it would be unfair for the farmer to have to pay for this when basically you're using his field as the catch basin for the entire system. The way it was designed, gravity being what it is, when the water rose, this is where it was going to come out. And so it was foreseeable and it was inherent in the plan. And so the court found inverse condemnation. Now, the 2006 case of CSA versus Palo Alto is basically turning it into strict liability, as we said, for sewer backups. So that is on the back of these prior cases, the water main break cases. Then the sewer backup case piggybacks on it, but it borrowed from flood control law and it made strict liability. This is where I turn it over to Peter, because we both worked on the case, but he took the laboring oar, argued this to the Court of Appeal and the Supreme Court. So Peter, you're on.
Hello, everybody. Yeah, so I had the honor of arguing this case to the California Supreme Court, and as you all know, we were successful with that. I kind of refer to the 2006 to 2019 as the dark ages, when CSAA was the law of the land, and it was basically just a completely strict liability, especially with the sewer backup cases, but even beyond that. And so I'm going to talk a little bit about the background of that case and how it went. We actually Burns General Counsel to CJPRMA, and the city of Oroville was in the CJPRMA pool. So when this event happened, and I'll go into more detail about it, but the city reacted, and CJPRMA's claims people reacted. Under CSAA, they were going to be liable for this. So they went in and did cleanup, and they started the repair work, etc. So briefly, what happened in the case was there was a sewer backup into a dental office. Not a good mix. Dentistry and sewage is not a good combination. The way it came down was, well, I should say, I don't know if everyone's familiar with the backwater valves, also called the backflow prevention devices. But essentially, the system is set up so that if there's a backup, and there's got to be backups. So if there's a backup, it's supposed to go out the next highest manhole. And if your property has any kind of fixtures, either drains or toilets or sinks, that are below the level of that manhole fixture, then you're supposed to have a backflow prevention device. And essentially, it's a one-way valve so that the sewage can come out of the building and it can't come back. And that was required by a City of Oroville ordinance as well as the Uniform Plumbing Code. And as it turns out, this building did not have one. And just as a throw in there, if you have any of these cases, you need to look and see if the law was followed on this, because this really shouldn't happen. There shouldn't be a circumstance where a backflow can happen without there being a requirement for a backflow prevention device. Although there may be some very old buildings where they're kind of grandfathered in. But anyway, it's something to check out if there is a backup and into a private property. So in this case, the claims people went in, did the cleanup, which they generally do for just public health reasons anyway, if they want to get this all cleaned up and then sorted out. But in light of CSAA, they were prepared, they were going to be paying for this. And plaintiff's counsel was fully aware of that. And their attitude was, this is a blank check. I mean, there's basically no defense. They're going to get their attorney's fees paid, and they're going to go for it on this. And so, besides the usual stuff, about 4 months into reconstruction of the dental office, they did some testing. I'm not even sure why they were doing the testing, but they found some E. coli. And even though the experts said, no, it couldn't possibly be from this event 4 months earlier, it still couldn't still be alive. It had to be from something else. Well, instead of spot cleaning this, they ripped out everything and restarted the whole project. And so by the time we get down the road, we're in the 7 figures on this case. They also had an insurance company called TDIC. It was the dentist insurance company. It was kind of a mutual insurance company that was very favorable to the dentist, and they were just writing checks to them too. So we end up with what's becoming an unsettlable case, and we get to the point where summary judgments are denied, and we get to the point where under government code, I want to say, I've got it written down here somewhere, it's 12. What is it?
Code of Civil Procedure. Yeah.
Yeah, Code of Civil Procedure, and I think it's 1260.040. It had a mechanism for condemnation to allow a finding before trial of liability, and it had and so it had been used in inverse condemnation, and it was in our case. And just as a heads up, the Supreme Court under Weiss later on said, no, that's not going to work for inverse condemnation. But it wasn't an issue in our case. Nobody was challenging that. But they did move under that. The trial court found in favor of the plaintiffs and relied on the CSAA. And even though we argued, and I thought argued pretty forcefully, that, CSAA, and I get a little triggered by this case, so let me compose myself, but it was one of the worst decisions I've come across. And CSAA, what they did was they took language from a flood control case that was Bel Air, and that case involved a historically flooded area where the flood control came in and they put in levees and they built it up and to protect property. And there was a well, say hypothetically, it was a 50-year rated storm protection, and we had a 25-year storm. It failed. And so what the court came in and said was, in this situation, if this flood control protection doesn't function as intended, then there is inverse condemnation liability. If it had functioned as intended and still overflowed, there wasn't going to be liability because the public entity had come in and put in this facility to save the property and protect it. And so the court's not going to impose a penalty, because who's going to come in and protect put in flood control protections if they're at risk for inverse condemnation, if they don't, even if they do what they're supposed to do but don't prevent a flood. So CSAA just snagged that language out of that case and applied it to sewer backup and said, hey, if the improvement does not function as intended, then you got inverse condemnation liability. So that was my opening line to the Supreme Court was, hey, under traditional inverse condemnation, if a public improvement causes damage when it's functioning as designed, then there's inverse condemnation liability. Under CSAA, the rule was if public improvement fails to function as intended and causes damage, there's inverse condemnation liability to the public entity. And that was the universe of possibilities. So when you get smiles and nods from the justices, you're feeling pretty good that this thing's going well. And we did end up with unanimous decisions from them. But stepping back a little bit, when we had the bad decision from the trial court, just prior to that, as CJPRMA, we wanted to settle out with the TIC, the insurance company, because they had a 7-figure lien claim, and those were real numbers. Stuff the plaintiffs were claiming had some fluff to it. So we cut a deal with TDIC. It was a 6-figure settlement. I forget what the number was, but it was dramatically less than the 7 figures that they added for their lien. But instead of just settling that case, we decided to take an assignment of the lien. So CJPRMA then stepped into the shoes of TDIC and put us in a better position to actually have a seat at the table and a seat at trial. And we would be able to present these claims and offset what the plaintiffs were saying. But it also allowed us to come in and be a party and participate in the litigation. So the bad decision came in from the trial court. We had a writ to have it reviewed. And I should say Mark Habib and Leah Jewel Rhodes were the defense counsel underneath us, and they were very instrumental as well. But they took a photo when we got the everything filed, and it was just a table with stacks and stacks of briefing and exhibits. And we got back, we're all thrilled, the beautiful embossed stamp saying that the writ was granted. And we thought, okay, we're in business. I mean, Court of Appeal is going to take this up on a writ. We're good. And then the case sat and sat and sat. It was about 3 years. We finally got notice of oral argument, and I figure it must have been moved to another panel or something, because that oral argument did not go well. I should note I was not there because I had a paid planned vacation, and so I didn't go to the Court of Appeal argument. But when I was preparing for it, I thought, how can we possibly lose this? This is, everything's in our favor. We're gonna win. And then when Byrne went, they didn't even allow him to argue. It was just Mr. Habib that was allowed to argue. But the Court of Appeal was really hostile. And Byrne can fill in if there's anything more specific. But they thought the city should have made sure that this backflow prevention device was in place. And they didn't, so the city was on the hook for the whole thing. They're really putting things in a backwards way. So we had that. It was an unpublished decision. And so the next move was to try and get Supreme Court review. And, I want to stress how very important it was, all the amicus support that we obtained. I don't know, we had 6, 7, 8 different entities and associations send in amicus letters to have the Supreme Court review this. And the chances of them reviewing an the chances of them reviewing a published decision even are really slim. The chances of them reviewing an unpublished decision is really a fractional percentage of the likelihood. But we had all this support. We had a very good story to tell them. We cited, there are, I believe, 3 unpublished decisions that actually went our way, but they're unpublished. And Byrne was involved in writing to the Court of Appeal on one of those cases to have it published. And it should have been published. It involved a backflow prevention device, wasn't there. And it was like the next step from CSAA, because oddly enough in CSAA, there was never a mention of backflow prevention devices. It just was never an issue. So these other cases, then that was an issue, and they, for the most part, went our way, but none of them were published. So
This is a
getting
little
that
bit,
reviewed by the Supreme Court, I
this
saw
is a little,
like, go ahead, Bert.
this is a little bit of inside baseball, but you're not allowed to cite unpublished opinions to the Court of Appeal or the Supreme Court. But when you're petitioning for writ review, for a review of it, you're allowed to do it because it goes to the issue of whether or not this is an issue capable of being repeated. So basically, it's an exception that lets you bring in cases where the public agencies won, but they weren't published, at least as part of the argument that they should take it up. And when they granted review, in this case, it was all 7 of the people on the Supreme Court voting. So we didn't think they were voting to take it up to affirm it. We thought, okay, we've got a chance here. Peter, back to you.
Yeah. So you've heard the expression squeal like a pig. That was the plaintiff's counsel when we cited these unpublished cases because they'd had a brouhaha with the defense counsel earlier in the case. But the Supreme Court agreed with us. No, those are relevant to whether it should be reviewed or not. And so, but I'll tell you, I also checking in, I called the clerk and just to check in, see how the case was going. So, oh, that's the one with all the amicus letters coming in. So yeah, I think it is. Is that unusual? We haven't seen that for that much for a couple of years. So it puts you on the map, so to speak. It puts you front and center. Hey, there's something, because they don't review very many of these cases. Again, especially unpublished cases. So you've got to be noticed by them, and that was a very effective tool to doing that. And when we got the one-liner, the email came in for that, and I thought, click on this. It's going to be, it's a one-liner review denied, and it was a one-liner review granted. And I remember Byrne was on the phone. I went into his office, showed him the fist pump, and figured at that point we were going to win. That was what I considered the biggest victory, is getting to that point. It also, just as something I will tell my clients when they ask me, what do I think a judge is going to do in a particular case? Say, well, let me tell you about a case I had where the trial court said absolutely not. The Court of Appeal unanimously was against us, and then the Supreme Court unanimously was for us. So what's any particular court going to do? Who knows? We got negative, and then positive. So you never know what a particular judge or even a particular Court of Appeal is going to do. So anyway, we got that unanimous decision. Talked a little bit about what it means. So on to the next slide. The California Supreme Court decided a public entity will not be liable under an inverse condemnation where the property owner by ordinance was required to have a BPD, it's a backflow prevention device, also known as a backwater valve, and did not comply, thus defeating the design. Then is entitled to expect property owners will comply with the law. The loss was not caused by an inherent risk presented by the deliberate design, construction, or maintenance of the public improvement. So again, Oroville had a specific ordinance that adopted the Uniform Plumbing Code, but I've argued, and I haven't had to do it to the court, but I think I've been pretty successful in convincing plaintiffs' attorneys that includes just the Uniform Plumbing Code, even if you don't have an ordinance. But I would highly recommend adopting an ordinance to make it that much clearer. Okay, so as we talked about a little bit earlier, the flood control, the court came down and actually completely agreed with us on this, that flood control law is a unique area of the law. And it's a situation where you've got historic flooding in a particular location. And so you want flood control districts and whoever else to come in to build flood control projects. And if you're going to make them strictly liable, if they don't stop the flood, that's going to discourage public entities from building those projects. So the court agreed that could not be simply pulled out and applied to other types of cases. Okay. Substantial cause. So this is from the Oroville decision. It's the concepts of inherent risk and substantial causation address somewhat overlapping considerations, but play distinct roles in the analysis of inverse condemnation. And both must be present for a public entity to be liable. Under the CSA and other cases, the rule was basically if the public improvement was any cause of the damage, we're going to be liable in inverse condemnation. And that is what the plaintiffs argued in the Supreme Court. And that's a tough argument. They actually had case law supporting them, but it's a really tough argument, and the Supreme Court rejected it. And as it says in the holding here, instead, a court reviewing an inverse condemnation claim arising from sewage overflow must consider whether the damages to private property were the direct and necessary effect of the inherent risks posed by the public improvement as deliberately designed, constructed, or maintained. And in a case like this, a reviewing court must assess whether the damages were the result of a risk created not by the public improvement, but by the acts of the private property owner. A causal connection between the public improvement and the property damage alone is insufficient to sustain a finding of inverse condemnation liability. So I think this language is broader than, certainly broader than just sewer backup cases. Also tend to think, and Vern's going to talk about this in a few slides, but when we're talking about comparative fault, I think there's some very good language in the Oroville holding that is a signpost that comparative fault should be a defense in inverse condemnation cases. And we're back to Vern.
Yeah, every first-year lawyer is taught a four-step duty, breach, causation, damages. For someone to win, they've got to show there was a duty that the defendant owed, that there was a breach of that duty, that there was causation, and that there was damage. The Supreme Court in Oroville kind of blurred them when they talked about that. We argued that not having a backflow device violated the code and defeated our design, and therefore we didn't have a breach. They looked at it more as a causation argument, that that our system didn't cause the breach. They're really the same argument, but they were different sides of the same coin. Now, there's been another case decided since then, and this is just in the last month, May 24th, it was decided, called Simple Avo Paradise Ranch versus Southern California Edison. And this is a fire case. public utilities can be sued for inverse condemnation as well because they have condemnation power. And that's why PG&E went bankrupt after all the fires. Well, this is a fire in Southern California. Southern Cal Edison got hit. And the reason I put this in here is because this is the first published case talking about Oroville and saying what Oroville Court stands for. And it's actually quite helpful. It'll end up being in all of your defense briefs at any mediation or summary judgment motion going forward. So this is a quote from the Simple Avo case saying that the Oroville court stated the focus of the substantial causation was on whether the proof the damages followed the normal course of subsequent events and were predominantly produced by the improvement. Accordingly, the court rejected strict liability standard. It went on. Oroville concluded it was not enough for the trial court to find the primary cause of the sewage backup was root intrusion. Sewage backup was not an inherent risk of the city's sewer system as deliberately designed and constructed. Instead, the sewer system was deliberately designed to include a backwater valve, which the evidence showed would have significantly reduced the risk of invasion. Thus, the backup of sewage in a plaintiff's offices was not the necessary result or unavoidable consequence of any risk posed by the sewer system. That is key language. This necessary result or unavoidable consequence will be the argument we make on proximate cause for any inverse case. And it could be a water main break, it could be a fire, it could be a tree limb dropping, it could be land subsidence, it could be any property damage that the agency is sued for. I want to switch away from inverse a little bit. Oh, I'm sorry. First about comparative fault and some of the defenses. In 1976, we became a comparative fault case state with Lee versus Yellow Cab. Up until that time, the rule was contributory negligence. If a plaintiff is also negligent in causing the injury, they recover nothing. So instead, we switched in 76 to a comparative fault system. In 1975, a case was decided that said you can't argue contributory negligence in an inverse case. It's basically a strict liability statute once the elements are found. But since Lee versus Yellow Cab, the Supreme Court has not decided whether or not comparative fault applies to inverse claims. They did grant hearing in one case where it was a flooding subsidence case. And then after they granted hearing and the briefs were filed, the plaintiff argued the state didn't properly maintain the issue at the lower level, plus they hadn't done anything to contribute to it. And knowing that there's flooding on your adjacent property is not actually comparative fault. So the court dismissed the petition and never actually made the decision. So there's not a case 100% on point that says whether comparative fault applies. There is case law, that, however, that says that you can file a cross complaint against somebody else. So, for example, if the adjacent property owner also contributed or a contractor contributed, under a case called San Mateo versus Bernie, you can file cross complaints for indemnity. The issue on comparative fault is right now open. The California Association of Joint Powers Authorities sponsored a bill that actually got introduced but didn't get out of committee that would have changed the Code of Civil Procedure to put a comparative fault defense in. And so that may come up again. There's an effort to try to fix that with statutes. One other issue is mitigation. Comparative fault is you did something before the loss to help cause it, and therefore you should have your recovery reduced. Mitigation is after the fact, and there is case law talking about having to take reasonable measures to protect your property after the loss has started. And Laughlin versus City of Lafayette is a flooding case where the Supreme Court talked about downstream landowner has to take reasonable measures. And so there's at least some argument for mitigation afterwards. So this is an area of expanding law. Remember, all of this goes back to the one sentence that we talked about in the California Constitution, and all of the rest of it is case law based on that. Coverage, just one quick slide on coverage. Stonewall Insurance Company versus Palos Verdes Estates is the main insurance coverage case on this. If you've got an inverse condemnation exclusion in your pool memorandum of coverage or in your insurance policy, if there are damages that are both under tort and inverse, they're covered, notwithstanding an inverse exclusion. But the damages that are only recoverable under inverse, like plaintiff's attorney fees and expert witness costs, would not be covered if you have an inverse exclusion. So it really depends on the language of the coverage document. In the Stonewall case, this was a earth movement over 4 years, 4 different policies, and finally it came down and destroyed a house. And they said each one of the 4 policies is triggered. Each one had different language. One of the carriers didn't reserve rights on inverse, even though it had an exclusion. Another one did. So the court, weaving through all this, said basically, if they overlap tort and inverse, you're covered. If it's inverse only, you're not covered. damages. Generally speaking, the basic rule is damages for property damage are diminution in property's fair market value as measured immediately before and immediately after the damage, or the cost to repair damage and restore the property. The Kelly versus CB&I contractors is a constructors is a fire damage case with a landlord and tenant involved, and they found essentially this two-step rule, which is also in the jury instructions. But Kelly also says there is sometimes a personal reason exception. So, for example, if you have something, well, for example, if you have a pet who's injured and you have a giant veterinarian bill, there might be a personal reason where you might incur more than the quote-unquote fair market value of the damage. Or if you have, for example, a family heirloom. We had a case once with CSRMA where the rug had been passed on from grandparents to children to the grandchildren and then get spoiled by a backup. And the question is, are we going to pay the fair market value of this old rug? Well, it was a family heirloom. So the question is, what's the value? As it turns out, we were able to get the thing cleaned at a very expensive rate. But the basic rule is diminution value or cost of repair, except when it's not, except when there's an exception. The general rule for property damage claims is that emotional distress is not covered for under government code dangerous condition claim or under inverse condemnation claim. The main case here, Ehrlich versus Menzies, is a case where the homeowners were complaining about the construction work that was done on their house, and they said they were afraid of a collapse. And they said, if you had any damage claim against the contractor, it's for the cost of repair. You can't throw emotional distress on top of that. And it cited some earlier cases, including one where a tractor lost its brakes and crashed into a house. And they said you can get back the cost of repair of your house, but you can't get the fact that you have emotional distress over the damage to your property. So that's the basic rule for property damage. But there's a difference rule for the nuisance cause of action. Under the nuisance statute, you can get damages for fear, discomfort, or annoyance. That's why it's so important to see if you can knock the nuisance cause of action out. Potter versus Firestone is a case where there was pollution coming from a disposal facility that the power company had, and they claimed they had fear of toxic exposure. So the court said you could get fear, discomfort, and annoyance, not emotional distress, but similar. So basically the rule is you can get no better than the cost of repair except when there's an exception, and you can get no emotional distress except when there's an exception. Blake versus Thompson Petroleum, I've included this here because it says the loss of use of property can only be claimed during the time that you're out. This is a fire inside of an auto repair shop, and it was closed down for 3 months. And the auto repair shop said, well, I lost customers and I'm going to lose money for years and years hereafter for this. And the court said, no, you can't do that. You can make a claim for lost income during the 3 months that you were out of business, but once you were back in to the shop, it's all speculative. And so it's a very helpful case in knocking down damage claims. Heinemann is a case that's an older case that it says under inverse condemnation, you cannot get emotional distress or annoyance or discomfort, any of those other kinds of damages. All you get is the value of the property. So this one comes up every once in a while when we get a sewer backup case and people say, well, I want an extra money on top of the repair costs, and we can cite this for them. As everybody knows, I've got it miscited, it's 1036, not 1038, but you can get attorney fees and expert costs. If there's ever any help from the legislature, I can't bet on the California legislature helping us out with anything, but if there was ever anything that they could do, they could amend the CCP and take down some of these damages, because this is what drives a lot of these claims. And of course, this is why at the outset of the case, you have to decide, are we going to dispute liability, maybe drive them into the arms of a lawyer, or are we going to try to make a deal with the homeowner who's not represented? The last 3 slides I'm going to go through pretty quickly are just to talk about exposure conditions. When can you, as an agency, be liable? Well, if you're talking about a storm drain or a sewer main, you can talk about accumulation of foreign materials, so you have to have an inspection program to try to clean them up. Tree roots that break in, especially old-fashioned clay pipes. Hydro flushing, unaware of a blockage. The CSRMA groups had a number of claims where they're doing the hydro flushing, they're jetting in the thing, and they don't realize that there's a blockage upstream and it ends up coming back out. So there can be some active issues as well. Damage to the pipe. I've seen cases where, the one utility is under there and they nick the pipe and then they cover it all up, and then you find out that there's a leak, and you can tell from the proximity of other utilities that it was caused that way. And then in a lot of those, you get encroachment permit issues too with indemnity claims. Infiltration of water into a sewer or drain system, and then deterioration over time, especially for water. That this is the biggest issue, because the Pac Bell and the McMahon's case both essentially require you to have some kind of maintenance and inspection program. Otherwise, you're going to get accused of not having or having a deliberate plan that's insufficient. Risk avoidance inspection program is crucial, especially high risk areas. Having a maintenance plan, getting a response plan. So you should be ready after a break. Do you have a deal with local hotels to put someone up if they're out of the house? Do you have contractors that you can call on an emergency basis? Do you have a deal with the restoration contractors, and you get a volume discount if you make a deal with them in advance? You'd rather have contractors that you don't want to hire them yourself necessarily. You want the homeowner to hire them, but you'd rather have someone you can recommend, so you keep them out of the arms of somebody who's going to overcharge them. After the loss, mitigation measures, super important to document a loss right from the start. If it's a sewer backup, of course, you have to report it to the water board, or if it's a water main break and it gets into the stream, you're going to have to report it anyway. Immediate remediation if you need to avoid health risks, and consider at the start whether you're going to accept fault or not. For a lot of districts that I work with, they look at the claimants as they're paying customers. They're not just members of the public. They're our customers. We want to take care of them if we've caused an injury. Reliability is disputed. That's when you want to say, go see your homeowner's carrier. We'll talk to the subrogation claim a year from now. Keep track of discarded items. I can't say how many times I've seen this where they throw stuff out and then all of a sudden, hey, my old shoes were worth a lot of money, or I lost all this artwork or something like that. So it's really important to take pictures and get them inventoried at the part. Repair or replace we talked about, and then restoration work can require code upgrade. This is the thing I have with adjusters who work for homeowners carriers or the property adjusters first. They hate the idea of paying for older property. But when you've got a third-party claim, and I've sold part of your wall-to-wall carpet, well, there's no market for wall-to-wall carpet. They have to be replaced with something new. It'd be different if I total my car. You can find a 5-year-old car of a similar model maybe, and there's a market price for it, so you can replace it. But a lot of times you can't. And so if you get water or sewage or something that gets into the sheetrock, and it's got asbestos in it, they're going to have to replace it. So you're going to have code upgrade costs too. As a third-party liability claim, that is something you're going to be looking at. It may not, if you were a homeowner carrier, you might say, I'm going to depreciate it. But on a third-party basis, it's something that you can be hit for. Thank you. I didn't give us a whole lot of time for questions, but we'll see.
Well, Bern, Peter, we appreciate it. We did get a few questions previously submitted by our members. And for the members that are watching now, if you'd like to put in questions in the chat feature, if we can't get to all the questions, Bern and Peter have agreed to answer all questions submitted, and it would be posted on the Water Leadership Group website. So starting out, and I'll defer Peter, Bern, to whomever wants to answer this question. The question is, based on the new rule for inherent risk and substantial causation, is the standard of liability now for inverse condemnation actions, whether it's a sewer backup or a water line break, is it the standard of reasonableness, or is there still a risk of strict liability?
My answer to that is it's not reasonableness in the sense of a negligence test, but it's a deliberate plan of maintenance. Basically, if you're going to show that we have a plan, but an accident happened, you've got a much better defense to liability. If you don't have a plan, then that'll be taken as evidence, basically.
And let me jump in on that, Paul. The Pac Bell case, the fix it when it breaks, they said this may have been a reasonable program because it probably saved them money, but that was not going to carry. It's still fix it when it breaks. That one member of the community who gets flooded is not going to bear the burden of what the community is saving on. So even though that was a reasonable approach, there was not actually a reasonable inspection program. So to that extent, There's still certainly potential liability after the Orville case for water pipes that are not being inspected in some manner.
It's a little analogous to the Monell case for civil rights liability, where you have to show that the entity had some kind of program or policy that caused the loss. The shift is not, did the inspector miss something or make a mistake? It's, what was the entity's plan? You know, was that something that deliberately shifted the risk, or, you know, took steps anyway to try to inspect and minimize the risk?
Well, thank you. I'll ask one final question, and then Vlad will hand it over to you for final thoughts. A quick answer, if you could, to both of you. Would you consider the Orville case a step in the right direction of calibration and fairness to public agencies, or a giant leap forward?
Well, I guess I'll jump on that one. I think it's a giant leap forward. And I think there's such broad, good language, not only in the Orville case, but the case that came out in May, that to me, and when it comes up, I'm going to be arguing comparative fault, you know, in whatever kind of situation it is, that not only is Orville established that, you know, you've got to have the public improvement functioning as intended, causing damage, but if there's any comparative fault, that's going to be considered too. And I know we're in time, so I'll hand it over to Bern to give his two cents.
The only other thing I'd say is there's still dangerous condition of public property liability. I mean, if our facilities caused an injury, then, and we had notice of a dangerous condition, then we'll be liable. What this does is it takes the wind out of the sails of the attorney fees and the expert witness costs, because it takes away the ability of the plaintiff's lawyer to say, I'll just litigate the heck out of this thing. All it does is mean my demand's going up. So I think it has some settlement value in addition to the, you know, liability exposure issues.
Great, thank you, Bern. Thank you, Peter. Vlad?
Thank you. Thanks, Paul, and thanks, Bern, Peter. Great presentation. We definitely packed a lot in today's session. And we will make the recording and the slides available to whoever would like to request it. Please let us know and we'll provide them. We will also post them on our website, so please check there as well. Again, the inverse condemnation, to me, it's one of the more important subjects that we deal with, and it seems that we do have some glimpse of hope in trying to reshape the way that the inverse condemnation cases play out. So I think Bern and Peter provided some valuable insights on how we can do that by arguing comparative fault, by working together to submit amicus briefs when the cases do come up for review. And again, it's one of the reasons we actually put this water leadership group together to try and influence the environment we all work in. So we will definitely be taking on some of those matters in the future. Bern and Peter, again, I just want to thank you for a very insightful presentation. I always wondered how this case unfolded in the back of my mind, and this was a very good roadmap of what went on and how you know, this became a landmark case. So thank you so much for your time. We really appreciate it. If there are any participants who are representative of water or wastewater agencies that are not part of our group and would like to join, please contact me offline and we can chat about that, or you can reach to Paul Fuller and he will be happy to help you as well. Thank you very much. That concludes our presentation, and we're looking forward to seeing you next month for the PFAS presentation that will be announced shortly. Thanks, everyone. Have a great day.
Thank you.
Thank you.